All right, Kathy, are we ready?
We are all set.
Okay, thank you so much. All right, good morning, everyone. It is 9:30 a.m. We are here for the monthly meeting of the Citizens Clean Elections Commission. And item 1 on the agenda today is the call to order. And it is 9:30 a.m. on July 29th, 2021. So I will go ahead and call the meeting to order. I'd like to ask the audience members to please keep their microphones on mute so that we can hear everybody when they're speaking clearly and for the record. And with that, we will take attendance. Commissioners, please identify yourselves for the record.
Good morning, Damian Meyer.
Mark Kimball.
Galen Payton.
And I am Amy Chan. And with that, we can move on to agenda item 2, which is discussion and possible action on minutes for the June 17th, 2021 meeting. Is there any discussion on the minutes? And if not, do I have a motion to approve the minutes?
Madam Chair,
Commissioner Kimball.
I move that we approve the minutes for the commission meeting of June 17th, 2021.
Thank you. Do I have a second?
It's Commissioner Meyer, I'll second.
Thank you. All right, I'm going to call the roll and we can vote on that. Commissioner Meyer?
Aye.
Commissioner Kimball?
Aye.
Commissioner Payton?
Aye.
And I vote aye as well. By a vote of 4-0, we have approved the minutes. Moving on to agenda item 3, discussion and possible action on executive director's report, enforcement and regulatory updates and legislative updates. So, Tom, you're going to present this as always. I'll turn it over to you.
Okay, I can just, okay. Commissioners, thank you very much. Commissioner Chairwoman Chan and commissioners, you know, I'm sure you've had a chance to look at the report. I think the big announcement for purposes of our next few months, maybe the next 18 months, is on August 1st, the qualifying period for participating candidates to collect qualifying contributions. As many of you know, and some of the audience may not, the way that the Clean Elections Funding Program works is that candidates for statewide or legislative office collect nominal $5 qualifying contributions from folks in their district or in the state who are registered voters. And by showing that support, and then foregoing PAC donations, large individual donations, and the like, the Clean Elections Funds provides a amount of money to go towards that election campaign. This is an old concept, a concept that's been in law since at least the early 1970s, and I don't know the history of when the idea was developed before that. One of the complicating issues this year is, as it was 10 years ago, is redistricting. As a staff, we have our views on what kinds of districts should apply for purposes of signing those qualifying slips. In other words, if you have to be a resident of the district, no one who's running for office right now, who's running for the legislature, knows what district they are in. But because the legislature has passed a law saying that the district you would have been in or could have been in, and that's not the precise little language, but there are a variety of locations within a district that can count for signatures, for petition signatures. We believe that that's true for qualifying contributions as well, because there's no separate definition of district. We have had some meetings with the Secretary of State's office on that issue. We're hopeful to have some formal confirmation that this Secretary of State shares the views of the prior of the Secretary of State's office from 2012. When we get that confirmation, I will let you all know if you want to know, and certainly we'll let candidates and folks involved in the election community know that. We had hoped to have that in place by now, but as you know, the Secretary's office is very busy. We have an election date coming up on August 3rd, Tucson, Prescott, Dewey, Humboldt, and the Oatman Fire District. So obviously the last day to mail back, the recommended last day was 2 days ago. Gina and Avery are working with the Secretary of State's office on exploring a virtual event with community-based organizations. Gina's continued to be a valued resource for the press in describing accurately what the and informatively what is going on with various election issues that keep doubling up, and has continued her efforts to develop her resume and skill set through the educational efforts she's undertaken. We did have a morning scoop segment we've been sponsoring with Cap Time. There was a discussion on new election laws that Cheryl Chan participated in, Gina Roberts participated in, and a couple of lawmakers and the lobbyist for the Secretary of State. We've got website updates where we're enhancing the terminology and issues there to make sure those are up to speed. We're working on just a variety of different things. You guys need to read the list, but I think that Avery, Gina, and Alec continue to be focused on the voter education thing, voter education duties. Meanwhile, as Mike and Paula and Julian are getting ready for the beginning of the qualifying period. So it's a relatively busy time, given that it's an otherwise off year. We're really we're hopeful that the governor's office has released a primer on a veterans workforce initiative they're doing. Avery was recommended as a potential candidate for veteran success stories, which is as part of the outreach efforts for this initiative. We're really excited for that. As you know, Avery is a veteran and also has been, really instrumental in recognizing and creating opportunities for outreach in ways that that have really, I think, enhanced what the agency can do to serve the public. On the usual election law stuff, and anyone can stop me with questions, or if you're tired of listening to me, because you may have read this, but we're still waiting for this a case called the Legacy Foundation Action Fund. That decision has now been that decision was conferenced in December. It's July, so hopefully. There are 2 public records cases on the audit in various stages at Superior Court. I think there may be a notice of appeal at least in one of them. There is a new lawsuit filed in the context of election law. The Free Enterprise Club filed a lawsuit against the Secretary of State and the Invest in Ed, I believe, group, basically saying that the legislation that in the legislature's view may have changed the tax rate, but in their view keeps the funding there from Prop 306. That because it's a tax and funding bill, it would be immune from referendum under the state constitution. I don't know that any hearing has been set for that. There is a provision in the Constitution that says that those basically what amounts to an appropriation bill, but the language is for the maintenance of state institutions, etc. That does not get to 90 days. So there's 3 referendums pulled. but under the argument is that under the Constitution, because these are akin to or are part of the appropriations and maintenance and operation process, they're just not subject to that 90 days. So we are also waiting for, I think, from an elections constitutional law perspective, for the case of fan versus state, which is essentially has to do with the legality of different parts of prop of the Invest in Ed proposition, and those issues are laid out there. That argument was again in April, so we hope to get some. Those are things that are off in the offing. And then finally, I just wanted to again thank the. We have one rule amendment on this agenda, and we're working with the Governor's Regulatory Review Council and staff on another amendment we have pending with them. So I just want to thank the Governor's Regulatory Review Council and its staff for their continued efforts to help us to provide them the information that we need, and frankly, to provide some pretty good notes on how we might in some cases make our rules a little clearer. And so that's great. It's nice. It's a good example of that system working. So that's so that concludes the report. I guess I did basically read the whole thing, but I'm sure I editorialized in there somewhere. So if you have any questions, I'm sorry.
Does anyone have questions or discussion? Sorry. And Tom, I think it's helpful for the audience to go over it. I know that's a lot for you to do, but for folks who are attending, I think it's wonderful for you to go over.
No, I know. I just don't. I worry about the being a little too boring.
We can't help that sometimes. Not that you were boring, but I mean, sometimes the stuff we talk about is just the nature of it might be a little bit, but that's why we're all here, right?
Yeah.
So don't even worry about it. All right. So I don't see any discussion or questions from the commission. I just want to say to Avery, congratulations. That's so exciting that, you were recommended for that program, or I don't even know if I really understand, but and I don't want to put Avery on the spot. I don't know if he wants to kind of tell us a little bit about that. But that sounds very exciting. And Avery, do you mind? Could you tell us a little bit about the program that you were recommended for?
Yeah, sure.
So sorry
Madam
to
Chair.
put you on the spot.
Yeah, no problem, Madam Chair, Commissioners. Paula had recommended me for the interview, and basically it was an interview where I went over my service in the Air Force and connected it to my employment with the state. So I guess they were using it for like a retention kind of marketing campaign, but it was really cool. I enjoyed it, and it was almost talking like I was talking to a younger version of myself. So it was interesting. But
Thank you so much. Again, sorry to put you on the spot. Gina, did you want to add to that?
If I could, Madam Chair, Commissioners, I do want to also note too, obviously we are all very grateful and appreciative of Avery's service, and it impacts voters directly too by having his expertise here. Avery actually created a video for us for clean elections and for the voters about UOCAVA voting, our uniformed and overseas voters. And so it was really helpful to have his experience about voting overseas and how it can further help us connect with our military and overseas voters, because they have a special set of voting laws and protections that cover them. And so, we've just found that Avery's service to our country has been very helpful as we reach and connect voters. So again, we're very grateful for him and that, of course, his service, but also his expertise that he's able to share with us as we reach voters.
Thank you. This is so exciting, so wonderful. Thank you so much, Avery. Thank you, Gina. And thank you, Tom. Do we have any comment? If any members of the public have comment on this item, you can signal the Zoom moderator, I think, in the chat. Okay, I don't see anything. So for now, we can move on to the next item, which is discussion and possible action on amendments to R20-101. And the commission may vote to begin a new public comment period for a rulemaking related to this item. And Tom, I hope you'll forgive me, but when I was looking at the packet, I felt like you had already opened this. Can you?
Yes.
Okay,
Yes.
go
Yes.
ahead.
Yes.
Yeah.
Precisely. And that. Yes, Madam Chair, Commissioner. So this is an example of, I think, a really positive work with the Governance Regulatory Review Council staff. So, we did initiate public comment on this rule, on a rule like this. What we did in that was we simply omitted a definition that was there. When we submitted that, the feedback we got, which I think was really spot on, was look, you use this terminology throughout the rules. It probably would be a better practice to state what the new criteria are. In other words, the upshot of this is that definition of family contribution in law changed. As a result, there's a correlating change in how the commission would have to treat that under the Clean Elections Act, and we want the rules to reflect that change. The GERC Council staff's recommendation was, look, since people may not realize the implication of that change without it being there, let's just put in the new terminology, which basically it has to do with expanding for that purpose to aunts and uncles and spouses and aunts and uncle spouses. It's just a broadening of who constitutes family member. I think that was a good idea. Now, because we think that was true, and this is just to back up and explain why we're here. Now, and I think the council staff view, and I think they're not wrong about this, is that because that was the intent of the rule, the change, we could have worked in this new language at GERC, right? And then said, well, no substantial change. It was my decision to say, and I'm only saying mine, not to brag, just to know where the accountability is supposed to be on this. It was my decision to say, look, I understand that, but I would prefer to have a more transparent record so that nobody thinks that we changed the meaning of terms or how they were used. So, this is one of those things that's a wrap-up thing. I think this issue of that definition has been an issue. It's been sort of not litigated directly, but it's implicated. So we've worked around this issue for quite some time. I don't think another 60 days, plus GERC's review is going to cost us that much. And I just think my personal view is it's the better course to do it that way. Simply do the 60 days, make sure everybody looks at the new language, makes their own determination if it's different, if they need to comment, if they don't, and then go from there. So that's the context there. In order to do that, obviously that means that the rulemaking we had would be terminated. I personally don't. I think the way this is set up, by starting the new rulemaking, if you were to so approve, you would be inherently terminating the old rulemaking, and I would file a termination notice with that. If we need to have two separate votes on termination, and it seems to me this is a binary thing. By opening the new docket, you're inherently closing out the old one. But so I think you can just. I believe that would be a sufficient motion, but I'm open to suggestions on how that, from Kara, if you would like that more effectively communicated. But bottom line is, all we're asking is to instead of formally remove the definition, we want to make sure that we want to leave the definition in place, but explain, specifically what the changes are.
Okay. Thank you, Tom, for explaining that for us. So are there any questions from the commissioners? I think that was a wonderful job of explaining why we're revisiting this. Thank you, Tom. Okay. Does not look like we have any questions from the commissioners. And so in that regard, would one of you like to make a motion regarding opening public comment on the amendment to R2-20-101? can one of you make a motion to open public comment on R2 20-101?
Madam Chair,
Oh, thank you. Yes.
this is Commissioner Kimball. I move that we open public comment on R2-20-101.
Thank you.
Commissioner Meyer, I'll second the motion.
All right. Thank you, Commissioner Meyer. Thank you, Mr. Payton. I see you also were going to help me out here. You guys left me hanging for a while here. All right. With that, I'll take the roll. I'll call the roll. Commissioner Meyer, how do you vote?
Aye.
Commissioner Kimball?
Aye.
Commissioner Payton?
Aye.
I vote aye as well. So by your vote of 4-0, we have opened public comment on the amendment to R2 20-101. Thank you. And with that, we can move on to our next item, discussion and possible action on legal issues with election budget and procedural measures from the 2021 session, including discussion and possible action on House Bill 2110 and Senate Bill 1819. So with that, Tom has some additional background to provide, I think.
Right. So, thank you, Madam Chair, Commissioner. So, look, these two bills so far are the two bills that came out of the session that we have the most concerns about. I've spent a lot of time reviewing these. I've talked to our attorneys. I've talked to other folks looking at this, and I think that for present purposes, this item here is not for action today. It's here to really just kind of give you all an opportunity to interact about what I'm about to lay out, which is what I recommend to do going forward. We do have some scheduling issues with OM, so if there's an executive session issue, I would prefer to hold that until another meeting. If there's not, I just want to say up front, my goal is not to put this item on the next agenda unless something were to change. So, HB 2110 has to do with the Commission's funding. It has to do with the way that the legislature made changes to how surcharges on civil and criminal penalties are assessed, and who assesses them, and what basis they assess them on. There are legal issues with respect to injury, but there are also going to be factual issues that simply won't develop until after September 29th when this bill becomes effective, if they do at all. So in other words, so just to bracket this decision and where we are, we know there's a 1-year statute of limitations. We know that this law, in our view, violates the Voter Protection Act as applied to the Clean Elections Commission. We also don't know if this will actually have a practical effect on the Clean Elections Commission's revenue. So, given that it's not effective yet, et cetera, our view is within at least that year time frame, depending upon how you look at the statute of limitations issue, we monitor. We don't need to act immediately. That's my recommendation. Okay, just to make that distinguish from anything that might be disclosing a legal confidence. That's 2110. Senate Bill 1819. Couple things. Number one, when the legislature passed this bill, this is part of the Budget Procedures Act. So it's not the main budget. It's not I'm going to get this wrong, but I think the feed bill is the main budget. The feed bill has some stuff about elections. The Budget Reconciliation Procedures Act also does. Some of those changes do have an impact on the commission. GERC's expanded power to self-petition itself. That's one. Two, despite the fact that we can still intervene in a challenge to the act, the new statute says that at least until 2023, the Attorney General is the sole decider of how to deal with election litigation. So there's tension there. And that tension carries on through the case law. And one of the cases that we dealt with last year is a case called Arizona Advocacy Network v. State. In that case, a lot of people paid attention to the fact that, yes, we lost on some issues related to some cross-references, but the court rejected the argument that the the filing officer could be given 100% say over how to do campaign finance law and supervene the Clean Elections Act, Clean Elections Commission's authority, right? That's what the court held. Similarly here, as soon as you put sole state officer in charge, we have a case from the Court of Appeals that says that's a clean election, that's a VPA issue. So my view is that that whatever the legislature has an issue here that has nothing to do with us, but nevertheless, the language is written in a way that it might. That said, I think that the key here for us and why we don't need to take action immediately is, will this come up in any kind of context that matters? In other words, the critical issues that would have to come up where this would be, now, whether or not there's a legal injury, again, that's a statute of limitations issue. That's an analysis that has to be taken at some point, but not today. In the short term, the kinds of factual scenarios that would come up that might trigger an issue here are things like if there was a direct challenge to the act and the Attorney General's office sought to settle that case by saying the act is unconstitutional. This statute doesn't deal very well with that situation because all we can do is intervene. But realistically, is that going to happen? I don't think we're the highest target on anybody's list. So again, it's sloppily drafted, and there are the compromises that have to be made in the budget, and I understand that. So what I'm trying to say is, I'm concerned about this language. We can monitor this language, but the kind of like DEFCON 5 situations that might trigger this being a real issue, I think we should wait and see if that actually happens before we would jump in preemptively. As we get closer to what we think the statute, one of the dates a statute of limitations might run from, we may have to review that decision. But for the time being, I think we know the legal issues, we know the things we want to monitor, and so as from an executive perspective, again, not a legal advice perspective, my recommendation is we monitor these things, we make sure people understand that they're there, but I'm not planning to come back to the commission with more until we have either before we have some event that triggers that, or we reach a point where we need to make a final decision about what constitutes an injury here. That's basically a long way of summing up we've had this on the agenda for 2 or 3 months. We've been working in the background to try to assess the risk versus the risk of not getting involved in something versus getting involved in something. And right now, I think there are a lot of separate acts by other folks and separate information we may be able to obtain that we would need before we would need to revisit this. So that's where we are. If anybody has any questions about that, obviously I'm happy to take them. I thought about putting together kind of a flow chart about this decision making. I ended up kind of going against that and not doing that. I don't know if that would be helpful to circulate, but it's basically a triage of here's what the law says in theory, here's what we know about the law in fact. We need to know, so we need to let the law in action, for lack of a better way of putting it, play out a little more before we determine whether or not we want to get involved in a not necessarily, I don't mean theory in the sense of no standing, I mean theory in the sense of the most prophylactic response.
Thank you, Tom. Do any of the commissioners have questions or comments on this item?
Madam Chair.
Commissioner Kimball?
Tom, I just want to be clear. So on the statute of limitations issue,
Yeah.
these provisions take place or take effect in late September.
Yeah.
And that starts the clock on the statute of limitations.
To be on, I mean, and we've already discussed this in open session, so it's really not, I mean, I'm not giving, this isn't, the idea of the statute of limitations. My view is that the most conservative view of the statute of limitations issue is the effective date. There's and then there's several different issues about what the latest date to file would be, but yeah, a conservative, small c conservative view would be a year from September 29th.
There is no no one could make a claim that the statute of limitations started when the legislation was approved or signed by the governor or anything.
No, I don't think so. We certainly in our experience, now people can make lashes arguments all they want, and the state makes lashes arguments no matter whether or not it's been a week or a year. It doesn't. The state's view essentially, and I'm being mildly sarcastic, but the state's view basically is if you don't sue the day after they decided you should have sued, it's latched. But that having been said, I don't see a lashes issue here. Like lashes being you waited too long to sue. I don't see the injury for the purposes, for example, of the funding. The injury literally can't accrue until the law changes, because right now judges simply can't do the thing that they simply can't do the thing that the bill will allow them to do until that day.
Okay. I just I guess I just want to make sure that we have a substantive discussion about this well before the statute of limitations expires in anyone's view, because I would hate for the limitation to come up and we haven't even talked about it, because I do think we have a lot to talk about here.
Okay, well, I think, and Madam Chair, Commissioner Kimball, I think that's a fair point, and I think we can. I think what we should do, and what I think I will do, just to be fully transparent, we can reconnoiter with Mary and talk about when to have that conversation. And we'll need to have some. I think we'll need to have some written guidance to help us with that analysis. I think we just need to look at scheduling that out to when the best time to do it is, and I think we can certainly get you feedback on when the best time to do that would be from Mary's perspective, and we'll make it happen.
Okay, thank you.
Thank you, Commissioner Kimball and Tom. Anyone else? Any other commissioners want to ask questions or make comments on this item? I appreciate everything you said, Tom, and I think I agree. I mean, I think we just need to see what actually happens, if I'm understanding you correctly.
Yeah, I mean, you can't. I mean, look, some of the Photo Protection Act stuff is to me pretty simple. Some of it's so simple it may not even. People may. I mean, you may. I mean, 1819 is a perfect example, right? The one that says, okay, the Attorney General is going to be the sole decider of things. Yet, I mean, I just don't think that anybody of election cases. I can say with some confidence that I don't think the people who initially started to put that language together were thinking about clean elections. And then they added in the exception for our ability to intervene. They recognized that. So now, on the other hand, could you get through a legislative body constituted as ours is with a kind of a more expansive definition of who is excluded that is comprehensive as to clean elections interest? I mean, we know that's a very difficult undertaking. Otherwise, we wouldn't be in the situation we are with 2110 and some other stuff. So, from a legislative perspective, I do want to emphasize this is as good as we could have asked for. So, the question really does become, we should see what the situation is, and then with the timeline that Commissioner Kimball bears in mind. It just seems like the most logical thing to do. I raise these things, and I think we all as staff raise these things on the basis of we want to make sure that things aren't surprising, and I think that having a plan, as Commissioner Kimball articulated, to have firmer thoughts on this is important. But that's really the point here, is to say, look, this is the lay of the land today. That could change. I'll give you an example, and I've used this example in describing this bill to other people. Some people routinely, whenever they file a response to a complaint against us, and we don't get complaints in the volume we once did, they will say, and by the way, the Clean Elections Act is unconstitutional for 8, 9, 10 reasons, or whatever they thought of. Now, is that person then going to try to go forward their response to the Attorney General and say, hey, we challenged the basis of the Clean Elections Act, and now you have to come in here and decide this complaint? Is that possible under this language? It's not impossible. Do I think it's a great argument? No. But we live in a world where I think that things that people did not think were good arguments or plausible arguments, or my judgment of what's plausible and good and appropriate as a claim is probably not the same as somebody who's got a client who wants to avoid the regulatory scheme. So it's just that's just the most salient example to me of something that we know comes up regularly in responses, that this language could be used to try to leverage, and that would be a situation where we would have some potential real stuff. I hope that example is salient enough to everybody.
I think it is. If there's no further question or comment, we don't need to take action on this. So
Absolutely not.
Okay. In that case, I will move us ahead to item 6, which is discussion and possible action on proposed meeting dates for August through November of 2021. You probably all noted that we're going to have to be flexible for November because we had some conflicts that prevented quorums on, I think, both dates that were presented. But if I could get someone to make a motion, we can, well, unless there is any discussion. Is there any discussion on this item? Okay. If not, let's go ahead and I'll entertain a motion to approve the proposed meeting dates for August through November 2021.
Madam Chair,
Yes, Commissioner Meyer.
I move that we approve the meeting dates for August to December 2021 identified in the materials today.
Thank you. I have a second.
Commissioner Kimball, second.
Thank you. All right, I will call the roll. Commissioner Meyer, how do you vote?
Aye.
Commissioner Kimball?
Aye.
Commissioner Payton?
Aye.
All right, and I vote aye as well. By a vote of 4-0, we have approved the proposed meeting dates for August through December. And with that, we can move on to agenda item 7. This is discussion and possible action on executive director compensation. And the commission may vote to adjust the executive director's salary and may vote to discuss this matter in executive session pursuant to ARS 431.03A1. And with that, this is the time set for us to discuss Tom's compensation. Kara, I think you're going to go over the process for discussion, executive session, and voting on this. Hopefully I'm not putting you too much on the spot.
Well, I mean, it's the typical procedure, Chairwoman, Commissioners, this is the typical procedure to the extent that you want to discuss salary and performance because it's a personnel matter. It's covered under the statutes and can be discussed in an executive session. Mr. Collins has been notified of his right to call for it to be an open session if he wants to. I have not received any indication that he wants it to be done in open session. Otherwise, you can be done in closed session. So sorry to put you on the spot, Tom. But
No. I mean, I honestly, I'll be honest with you. I have no opinion about executive session or non-executive session.
Okay.
I really, I have a technical question about in terms of the agenda item. Well, but I'll leave it to Kara to decide whether or not, what constitutes a discussion apropos of compensation and if that's a limitation on what we can talk about. But I have nothing to. I'm happy to answer questions, and I'm happy to do that in open session. If I don't know the answer to a question that's key to any of your decisions, obviously I'm happy to get that. And if we need to make this, if we had to table this or do this another time, that's all fine too. So I'm at your disposal, really. My predisposition is to do it in open session only because we do a lot of stuff in open session.
I think personnel matters are good for executive session, frankly.
Okay.
But
all right.
and then
Well, it's up.
it's up to you. Yeah.
I defer to.
You have the right to.
I have the right.
Yeah.
I have the right. So if I were to. All right. Well, let's go into executive session then, because that way you can, and then I guess Kara can keep us monitored on if we get too far afield, right?
yes,
Perfect.
Okay.
I'll go into open session with you guys.
And then
First,
I'll entertain a motion to go into executive session, but prior to that, I just want to make sure we communicate to Kathy Herring, who's our Zoom coordinator. I hope that's the right title. Which people go into the executive session with us. So maybe we can just make that clear before. I remember there were some questions last time. So I know obviously all the commissioners and Kara, obviously, I think Tom and anyone else need to be there, or I mean, court reporter, obviously.
court reporter.
Is Paula?
I was wondering if Paula could be there just to provide any historical context, but is that acceptable?
I'm happy to be there if you wish.
That I would appreciate it.
Okay.
And
all
then
right.
Do we need to log out, or we just stay right where we're at?
You're going to stay right where you're at, I think, and Kathy's going to take care of everything for us.
And so those invited to executive session will receive an invite to join a breakout room. And there is no limit on the time of the breakout room, and participants are allowed to return to this main session at any time. And it will not be live streamed, but those staying in this meeting and not joining executive session, the live stream will continue.
And I'm sorry to interrupt Commissioner Chan and
Sure.
commissioners, but Kyle should also be Kyle Cummings.
Oh, I apologize, Mr. Cummings. Of course. Thank you so much, Kara. This is exactly what I needed for Kathy's, make sure Kathy knows who to let in. Okay, with that, unless commissioners have questions for Kara, we can go ahead and I'll entertain a motion to go into executive session.
Madam Chair,
Commissioner Kimball?
I move we go into executive session for item 7, discussion possible action on executive director compensation.
Thank you. Do I have a second?
Second.
Thank you. All right, and I have to call the roll, right, Kara, for this, or did we just, okay. Commissioner Meyer, how do you vote?
Aye.
Commissioner Kimball,
Aye.
Commissioner Payton,
Aye.
and I vote aye as well. So by vote of 4-0, we have voted to go into executive session on item 7. So thank you.
Okay, the room is now open.
Thank you, Kathy. All right. I want to make sure we got everybody back.
I just closed the room, so everyone should be back in this meeting.
Okay, great. I would like to entertain a motion to raise our executive director's compensation, annual compensation, to $150,000 a year.
Madam Chair, Commissioner Meyer.
Commissioner Meyer,
So moved.
thank you. Is there a second?
Commissioner Kimball, second.
Thank you, Commissioner Kimball. With that, I'll call the roll. Commissioner Meyer, how do you vote?
Aye.
Okay. Commissioner Kimball,
Aye.
Commissioner Payton,
Aye.
and I vote aye as well. And by our votes of 4 ayes and 0 nays, we have voted to raise our executive director's compensation to $150,000 a year. Thank you very much. And with that, we can move on to public comment. This is the time for consideration of comments and suggestions from the public. Action taken as a result of public comment will be limited to directing staff to study the matter or rescheduling the matter for further consideration and decision at a later date, or responding to criticism. Does any member of the public wish to make comments at this time? I do see that Rivko has her hand raised. Let me just comment or give out the information that you can also send comments to the commission by mail or email at ccec@azcleanelections.gov. And with that, Rivko.
Yes, thank you
Nice to
very
see
much.
you.
I am not dressed for public view, and that's the great thing about Zoom, is it allows me to speak anyway. I just
Excellent.
wanted to compliment the commissioners and staff on hosting another very interesting morning Zoom. Morning Zoom, yeah. Morning Scoop, what am I saying? I've got my Zooms mixed up. Morning Scoop this morning. And it pointed out more than almost anything else how important voter education is going to be. We have no way of knowing, as was discussed this morning, how many of the voting changes will actually go into effect because of referendums that are being circulated. But there are already some changes that went into effect, and certainly people will be hearing and reading and etc. about changes. And so I just want to commend you for hosting that. Hope you will do more of them on election issues, which are continuing to move along. And then it just reiterates the tremendous importance of voter education and clarification that the Clean Elections Commission does. And that's all I wanted to say, but I feel it's important that that be said and be on the record. Thank you very much and have a good day.
Thank you so much, Rivko. Yeah, Gina, coordinates all of our voter outreach, and the Morning Scoop sponsorship is part of that. And she did a fantastic job coordinating it. I was lucky enough to be on the panel this morning and just really enjoyed the discussion. I thought it was really wonderful. And it would have been nice actually to have Kelly Townsend there. She unfortunately had an emergency that prevented her from attending. It would have been a nice conversation, but the people who attended as well were very active with their questions, which was wonderful to see all the engagement. So I would encourage everybody who has an opportunity to attend more of those. Those are pretty nice events. So anybody else from the public have comments, or let's see. Oh, we have a comment from Mary Ganapole. She wishes Townsend had sent a replacement. Maybe next time. I don't know. I guess the nature of the emergency prevented it, I suppose. But okay. If there's no further comments or questions for the commission, I will go ahead and move on to item 8, sorry. No, apologize. Item 9, adjournment. We had a few more items than usual today. So I will entertain a motion to adjourn at this time.
Move that we adjourn the meeting.
Thank you, Commissioner Meyer.
I second. Commissioner Kimball, second.
Thank you, Commissioner Kimball. With that, let me call the roll. Commissioner Meyer, how do you vote?
Aye.
Commissioner Kimball?
Aye.
Commissioner Payton?
Aye.
All right, and I vote aye as well. And by your votes of 4-0, we are adjourning the meeting. So meeting is adjourned. We'll see you next time. Thank you all.
Bye-bye.